presenting a session focusing on addressing copyright literacy in a time of crisis. To follow on, we have Bartholomew Milletti from the University of Glasgow, focusing on the creative reuse and the public domain, and the UK Exceptions and Best Practice Codes Initiative, and Dr. Thomas Margoni from the University of Glasgow, covering the European Copyright Directive and changes made to Article 17. James Bennet will round off the event going over the recent changes to the CLA licence in light of the current global situation. Before we start properly, I'm just watching the time, I will just give you some biographical background on our speakers today. And I'll do this all at once so it doesn't interrupt the flow, as Greg said. Chris Morrison is the Copyright Licensing and Policy Manager at the University of Kent, and Jane Seeker is Senior Lecturer in Educational Development at City University of London. As you will probably know, Chris and Jane are on a mission to make learning about copyright fun, engaging, and empowering. Chris is, I've just said what their roles are. Chris is a Copyright Licensing and Policy Manager at the University of Kent. And both Chris and Jane are engaged with the UK Copyright Literacy Organisation. Bartholomew Milletti is Creative Director for CREATE, the UK Copyright and Creative Economy Centre at the University of Glasgow. Bartholomew works as Creative Director for CREATE at the University of Glasgow. In this capacity, he's led the development of the copyrightuser.org, an independent online platform intended to make UK copyright law accessible to everyone. Bartholomew is also the Copyright Services Delivery Manager of Learning on Screen, a membership organisation specialised in the use of moving image and sound in education. In addition, he's Director of Worth Knowing Production, a digital creative team specialised in making complex knowledge accessible to everyone through research-based visual tools. Previously, he worked at the British Film Institute and Digital Catapult on secondment from CREATE, and has held research and media production positions at CIPPM, the Centre for Intellectual Property, Policy and Management at Bournemouth University, where he's currently a visiting fellow, and at CEMP, the Centre for Excellence in Media Practice at Bournemouth University. In 2015, and alongside Professor Ronan Deasley, Bartholomew received the Arts and Humanities Research Council's Award for Innovation in Film. This was for their work, The Adventure of the Girl with the Light Blue Hair, the first episode in The Game Is On web series. Thomas Margoni is Senior Lecturer in Intellectual Property and Internet Law and Co-Director of CREATE at the School of Law at the University of Glasgow. He also convenes the LLM Programme in Intellectual Property and the Digital Economy. His research concentrates on the relationship between law, especially intellectual property, and new technologies, with particular attention to the role of the internet and more recently artificial intelligence as new means to access, create, and disseminate knowledge and information. Recent examples of research projects include Recreating Europe, the EU H2020 project, which will engage closely with stakeholders in the creative industries to develop an integrated policy approach to copyright in the EU digital single market, where Thomas leads the task force on AI and data ownership. Open Air Advance, the EU H2020 project to support open science in the EU. Open MINDET, sorry, I'm getting totally mixed up. Open Min TED, the EU H2020 project for the development of an e-infrastructure for text and data mining, TDM in Europe, where Thomas coordinated the legal working group, and the data licensing project funded by JISC. James Bennet is Head of Rights and Licensing at the Copyright Licensing Agency. the UK collective management organisation for books, magazines and journals. CLA licenses educational institutions, businesses and public bodies to copy and reuse extracts from print and digital publications on behalf of the copyright owners, authors, publishers and visual artists. James is responsible for maintaining the value and relevance of CLA licensed products and services and developing new licensing solutions that balance the interests of rights holder with the opportunities provided by new technologies. Before joining CLA, James held a number of editorial roles in book trade publishing. He holds an MBA from Henley Business School. That is enough from me, given I was very late. So I will hand over to our first speakers, and that's Copyright Literacy in a Time of Crisis with Chris and Jane. Thank you very much.
Good morning, everyone.
Morning, everybody. This is Jane.
Thank you, Jeanette. Yeah, thank you, Jeanette. Thank you, Greg. Ideally, we would definitely like to be in Scotland today and not stuck in our respective bedrooms on the end of yet another video chat. But we're really pleased to be here. So this great lineup. We've got some great speakers, and I think they'll all come together, won't it?
Definitely. We were also delighted to be at the launch event last year in Edinburgh at the National Library of Scotland, or the relaunch of the SCURL copyright group. So it's lovely to be able to speak to you this morning as well.
Yeah. So we're going to be talking about copyright literacy at a time of crisis. What's been happening over the past few months? What have we been doing? I know a number of the people on the call have been involved in the discussions in the community. So we're going to start off, and let's see if the slide progression works. This is us. So everyone, can I just check everyone can see the slide of me and Jane?
I think so.
Jane in front of the books, me in the library. This is us. So Jane, do you want to say anything about us?
Well, Jeanette did an introduction to us, but I think, you know, it's interesting. I work as a senior lecturer in educational development, but I do teach about technology enabled academic practice. So I've been incredibly in demand at the moment, as most of the staff want to just have 5 minutes getting up to speed on online learning. But before that, I was the copyright advisor at the London School of Economics. That's when Chris and I started collaborating together. So, and my specialty was copyright and online learning. So I feel this is kind of my moment in a way, if you could say that about a pandemic and the situation we find ourselves in.
Yeah, and my background, so prior to being at Kent, I was at the British Library as the copyright assurance manager. But before that, I was working for a copyright collecting society, which was PRS for music, so the Music Copyright Collecting Society. So I've seen the copyright discussions from a number of different perspectives. And I think, you know, at the moment, education is such an important issue. And I think this is a really good opportunity to try to bring those different perspectives to bear, to try to resolve some of the challenges that we have around providing education experience and ongoing research, and making sure copyright doesn't become a barrier. So what's the issue? What's the problem that we see with online access? So Jane, you wrote a book.
I mean, I think for me, this is a problem, I think, that I recognised fairly early in my career. I started working on digitisation projects in the late 90s. And very quickly, the idea of getting access to core readings and how to make those available to students on platforms. When I worked on a project at UCL, copyright reared its ugly head, shall we say. I wrote Copyright and E-Learning, the first edition. I did a lot of the work on it sort of 2008, 2009. It came out in 2010. I remember Charles Oppenheim telling me I was very brave to tackle this subject. It was a sort of new area, and that people would be looking for advice and guidance. And
that's a code word if ever I heard one, isn't it?
Brave. And but I'll be completely honest. It's a fairly niche subject, and I've always thought it was a fairly niche subject. When I updated the book started to do the work in 2015, sort of just after the Hargreaves review and the law had changed, I felt I needed a bit of a kind of a shake-up, I guess, and somebody to give me some insights into particularly, how things were changing. And so Chris agreed to collaborate with me on the second edition. We've been looking at the moment at where we go next with the third edition, but looking at the changes that we made, they were really quite significant actually in 5 years between the two editions coming out. And I think it had become much clearer in 2016 when the book came out that copyright was quite an issue with online learning. I don't think anyone would be in any doubt now. I'm not saying that third edition is going to be a bestseller, but I think it's a hugely growing area. But what we wanted to say here was that this isn't new. This isn't something, that's just come about. Most of the issues that we're all grappling with at the moment related to this sort of rapid shift to online have been around for a very long time. And actually, I think we have many of the solutions already.
Yeah. So what happened when we first found that we were all going to be locked down and students weren't going to be able to come on campuses easily, we've since been writing about these issues and as Jane says, pointing back towards the points that we've been writing about for a number of years. They're not new. This is the most recent piece that we've written and was published this week, and which we've had published on One Key, the policy in HE blog. And the purpose of this is to try to raise the awareness of the questions that we all have been trying to deal with, and raise those with management in higher education, and try to link the different questions together, because copyright, you can see it from different perspectives, from the perspective of a creator or a user of copyright, and of course we're all both of those things, and that can lead to it becoming a confusing thing, which can be difficult to make decisions and policy statements around. So this one seems to be picking up momentum. But the first the blog that we wrote was way back in March 18th, when we could tell that things clearly were going to be different, and some big challenges around the status quo for people being on site, getting hold of physical media was going to be restricted. So again, this piece, which we put on our own blog, was a clarification that there were already provisions in place in the law and licenses that institutions were paying for, and ways that you could get access to content, and therefore didn't need sort of a panic, as it were, to say, oh, there's nothing that we can do, everything's locked down. But there are still significant challenges. So that's why we led ourselves to think, well, it's a time to have conversation in the community.
So that blog post, after some discussion on the mailing list CopySeek, led to the suggestion that we run our first webinar, which we ran on the 20th of March. I don't think Chris and I thought for a moment when we said that week that we would run this first session that sort of 12, 13, 14 weeks later we would be running these on a weekly basis. But if you haven't tuned in, we've actually got recordings available. We've set up this website that indexes all the webinars that we've done to date, it's become a really important place to have a conversation. Most of them are open as well, so just to sort of clarify that they are open to anyone to join in. We regularly get in around 100 people every Friday, and we've got one scheduled tomorrow if you wish to join, although actually tomorrow's I think will be closed, so you will need to be on List CopySeek to get the details for that one. But
to clarify, List CopySeek is the email distribution list that Jane and I are the moderators of, where much of the discussion around copyright and how you interpret the law and how you get permission and how you interpret exceptions happen. So if you're not a member and you're interested, then please do get in touch.
Yeah.
So we are going to very quickly run through the basics for those not familiar of what copyright is, how it works. So copyright protects certain types of things. So literary, artistic, musical, dramatic works, typographical arrangements, broadcasts, films, sound recordings. There are things which are in the public domain. There's crown copyright, performances, etc. These icons are all taken from the Copyright the Card game. I think I have a deck of the cards up here, so I will show them off, and they're in the box. So there are stuff that's protected by copyright. There are usages, activities that copyright regulates, such as copying, issuing copies to the public, rental or lending, performing, communication to the public by means of electronic transmission and adaptation. If you're doing any of those with a copyright work, you need to do that legally. You can either do that by getting a license, which is a legal use with permission from the copyright holder. And here are a range of licenses, including the CLA license. We have James Bennet with us today, who is going to talk about the CLA license. There's also the ERA license for broadcast content that's recorded. But there are other licenses as well that we would use in education, such as primary licenses from publishers for ebooks and journals. And then finally, you have exceptions, which is legal use without the permission of the copyright holder, but according to the provisions of the law. And one of the key concepts there being fair dealing. So we talk a lot in our community about how you interpret those exceptions and what can you do. And that's a really important aspect of where we are. So as I said, we have a number of licenses here. These are the key ones that we talk about a lot: primary resources, CLA, getting permission directly from people, ERA, and that underlines the Bob online resource that Learning on Screen run, and Creative Commons, clearly very important at this moment in time, because Creative Commons licensed content is really coming into its own at a time when people need access online, and the Creative Commons licenses provide permissive reuse rights for a lot of educational content. Exceptions here, a selection of things such as research and private study, text and data mining, recording from TV and radio, quotation, illustration for instruction. So these are all within our Copyright the Card game deck. I would urge you to have a look at that. Greg has created an online version of that, and I think now this is something we need to put a bit of focus into to see whether we can do that, because playing the card game does involve actually getting together and having a look at the cards. And whilst we think there's no real substitution for actually getting together and having conversations, clearly the likelihood of that happening anytime soon is going to be a tricky one. So Jane, what are the things with academic perceptions? Are all academics at your institution dabbing?
I think many of us know that copyright is probably not on the top list of priorities of things to be focusing on for most of our academics on a daily basis. So this was actually my attempt to find an academic trying to shy away from something. Yeah. But
you're not really up to date with modern pop culture, are you?
I'm not at all. No. So
it's the lofty academic approach that you take.
Yeah, the idea that many of them sort of are really, I would say, quite unaware. There's a sort of broad idea that educational use is kind of generally okay, but many academics, as we say in our piece that we wrote for Wonky, sort of fly under the radar a bit. They're kind of slightly suspecting they might be doing something that perhaps might be infringing at times, but they often don't ask the questions. They don't, even if there is, and there usually is, a copyright specialist. Some of them will be quite reluctant to come forward and explain in great detail what they're doing. So I think, certainly at a time like now when staff are being expected to shift to online learning, it's even more important that we don't, that they don't shy away from asking copyright questions. We need to understand what it is that they're doing and to be able to give them the advice of how to best do that, legally. So
the issue is that that's about how they use copyright. And of course, one of the things that we've found from our research is that, and we say in the paper, academics are writing the content. So that that there is an issue with the fact that they create copyright protected content and generally sign those over to publishers, and that has raised the issue around ebook licensing in particular.
And this is particularly related, I think, to the content that we use for teaching. So we've all been talking about open access to research outputs for a long time. We've been trying to raise awareness with academic staff about access to research. But in fact, what the pandemic has really highlighted is the fact that a lot of our content that's used primarily, to teach students is either not available in electronic format. It's available as a textbook that's designed for students to buy, and what our libraries have tended to do is stock multiple copies of those and use the CLA license perhaps to digitise one chapter. Or if it is available, then I think many of us are finding that some of the pricing that's being offered for some of this content is just prohibitively expensive. So it's something that GIST Collections have been doing a lot of work to gather evidence where some of these problems lie, and to try to come to a better solution for the community. So there was a statement that some of you might have seen that was issued yesterday from Universities UK and GISC about the need for affordable content, particularly for teaching. So it's something, again, I think this is not a new issue. This is something that the pandemic's highlighted, but this was actually something we picked up in some research we did last year into the use of the CLA license, where we suspected in some cases it was being used as a kind of workaround for when ebook licensing models weren't working.
So absolutely, there's an issue there, but as I mentioned earlier on, it does relate to this question of ownership of copyright. That is a vexed question. It's very topical at the moment in relation to the UKRI review of open access. So we're talking about research outputs and who gets to own the copyright, who gets to decide, who controls how things are made available, and how does that work with the funding and sustainability. But the issue here, and we make reference frequently to Lizzie Gadd's work, and she did some analysis, Lizzie Gadd at Loughborough, into university intellectual property policies and how they relate to copyright in research outputs and teaching materials. There's a sort of, I'm not sure I want to use the word moral. There's a moral argument because moral rights are something quite specific in copyright law, but nonetheless, there's the sort of technical how the law works, and then there's this whole cultural aspect of how academics feel about their institutions control over what they do, about the relationship between them and third-party commercial organizations. And it's something where, from our perspective, and we realize there's a lot of different views on this and how things should work, but we want to try to cut through some of the misconceptions and the fact that questions of ownership and control of copyright material are often so tied up in complex legal language that it's very hard for an academic to make sense of it. And in that lies a lot of opportunity for confusion and getting sidetracked from the issue of how do we get content to students? How do we get researchers to get access to research? How do we create an environment where people are thriving and are not excluded from certain opportunities? And that's really where and here's that lovely picture that you chose, Jane, of why that means critical. I'm not sure, somebody perhaps getting frustrated, but for us, when we're talking about the critical aspect of copyright, what we mean is copyright is not a natural state of affairs. It is something that humans have created in order to try to generate the economic conditions for the creation and dissemination of creative works. And those of us who are generally trying to provide access within an institutional context, so librarians and academics and learning technologists, we have an opportunity here not just to take copyright law as something which is presented to us by lawyers and commercial organizations, but to be part of a critical discussion, and not just about talking about it, but actually what we do, And that's why our definition of copyright literacy, which is in the second edition of Copyright and E-Learning that Jane mentioned, is about not just acquiring knowledge. It is about that, but it's also demonstrating behaviors and skills. It's around ethical creation and use of copyright material. We think that the ethical dimension is really important. But actually, specifically what you do and how you interpret the law, to some extent, is up for grabs, which is not an easy thing to do, because as we know, there are tensions. Here you go, here's some Highland games for you. We just thought we'd do something relatively Scottish. But we know that those tensions are there. It's not easy to have those conversations. But it's not, recognizing that academics are sometimes wary of what their institution's motives are, and particularly at a time of extreme financial pressure, and people trying to shift to a brand new way of thinking. We know it's not easy, but we think that there is also power in the fact that we are a community. So Jane, this is us a few years ago, isn't it? You don't have to wear matching T-shirts to be part of a copyright community, but it does sometimes help.
Yes. I think you could have a think about that as your Scottish copyright community. What you would have as your T-shirt for 2020. But no, I mean, I think the reason here being not just many of us, and Chris and I did some research a few years ago about the role of copyright specialists, and I think what we found is that many of these people feel often quite isolated. They do a specialist role within their institution. Sometimes they feel a bit like the weight of the world is on their shoulder, and when they come together, whether it's on a mailing list, whether it's through events that are run like today, like the event that we were at, which is one of our Universities UK copyright sort of summer events, people actually start to realise that by sort of sharing experiences, there is, there's a lot to be gained, and there's a lot of confidence that the sector can gain in working together. So, it's really to say that as a community, we can work together to come up with good practice. We can share experiences. We can also, because in our community, what we do have is, we have institutions that perhaps have more power. We have to be aware in communities, everyone isn't equal, and some of our larger institutions may be more willing to take risks, to go out and make bold statements about what they think is acceptable. And then, that can really sort of help, I think, galvanise the community to come together to, particularly we've heard from people in very small institutions, perhaps specialist arts institutions, where they feel quite nervous about amending a copyright policy to encourage staff to use exceptions, because who are they to do this? They're a small institution, they may be more vulnerable to sort of legal action. But the power of community, I think, is actually in sharing experience, but to come together to share really good practice and to feel actually that there is strength in numbers here.
But I think it's a really important point. But I think those of us who are copyright specialists need to bear in mind that we cannot go to people with just the copyright message. It has to be in context. And here's why what Jane's been doing at City, I think, is really innovative and an excellent way of approaching this. Not easy for everyone to do, but copyright here runs through your module on digital literacies and open practice. Even though you're not framing it as copyright training, it's part of a module in getting academics to think about their own practice and be part of that critical discussion about creation and dissemination without it being, oh God, we've got to go on some copyright training.
Yeah, so that's that if you're interested in finding out more, I'll put the website, because I'm aware we're running out of time. But thank you, Chris, and you've been a speaker. I've got a webinar series, and there are recordings up from the last 2 years that I've run this module, and it is due to run again in October in a fully online mode. So and there will be opportunities for people to participate certainly in the webinars, which they always have been able to.
Yeah, And I've also been taking a similar, well, from my perspective at Kent, I'm in a more of a policy role than an academic development role. So I've been looking at channeling what Jade and I have been doing into a copyright literacy strategy. So we've actually agreed this. Well, I'm still waiting to hear about what's come out of yesterday's Senate meeting, where it should be the final stage in the approval of this. But as far as I'm concerned, we now have a strategy at Kent, which talks about putting this kind of stuff in context, sets out a vision that in 5 years' time, people at the university will feel confident in making informed decisions about using copyright material, as well as understanding the role it plays in innovation and creation of new knowledge. So watch this space. There'll be more of that. We'll cover it in detail when we're ready to do our launch as part of our webinar series. And the sort of final thing we wanted to draw attention to is in the blog post as well. You'll be hearing more about in a moment, because we have Bart talking about this project to create a code of fair practice. So it's not just about discussing things in a critical way. It's not just about having a strategy or a policy that underpins it. People clearly need guidance of what to do in a practical context. And I think we'll avoid saying too much more about this because we don't want to steal Bart's thunder. But Jane, I think to finish up, you got an image from a book that you've been reading recently. Do you want to talk to us about this?
Yeah, so I don't know if people have seen this beautiful, beautiful book. It came out last year, and the author, Chris is going to tell me how you pronounce Charlie. You don't know how.
Is it McKeesey?
We don't know.
I'm sure everybody on the call will be able to put us right.
I was reading the book and I'm following the author on Twitter as well, but it's got so many lovely messages at the moment. If you're feeling down and you're feeling like you need to be uplifted, please go and buy this book. I am a huge fan of it, but it really chimed with me, this page, because Chris and I have talked for a long time about people being anxious and scared about copyright, and we did quite a bit of research on this, on librarians' experience of copyright and wanting to avoid it. And this idea that, recognising that actually we're all a little bit scared, but it is about the power of community, and together we can all be a bit less scared about copyright and help tackle some of the really important issues actually at the moment that are facing society, where we certainly don't want copyright being the barrier. So I think we'll end there.
We will end there. We will also point out that we have credits in providing attribution for all the images that we use, so that we may clearly rely on sections 30 and 32 of the Copyright Designs and Patents Act, covering quotation and illustration for instruction. And also we have some references here. So when we, you can circulate the slides, which are all, our content is all Creative Commons licensed, but here's the link to some other material that's all accessible, not behind the paywall.
There's a couple of, just to point out that there's been an excellent paper that came out by Dr. Emily Hudson and Paul Ragg. They spoke on our webinar last week about their proposals for copyright law in education during the pandemic. So we've got their SSRM paper there, which is well worth a read too, for those who are looking for a legal analysis.
Yeah, so thank you very much. I'll stop sharing the screen now. That's our presentation. So Greg, I'm not sure, do we have any time for questions? How are you going to do it using a password service?
Yep. Hi Chris, yep, we should do. So if anyone has any questions, if they could please just raise their hand or put them into the chat box, that'd be great, thanks. But just to pick up on what you were both saying during your excellent presentation, I think, as you rightly highlighted, I think the pandemic has heightened the importance of copyright, because that's something I've encountered within my own institution at the University of Glasgow. I've noticed that as well. The staff, there seems to be a kind of heightened awareness now of it, and I liked how you also mentioned the theme of community as well, because I think that's very important. As a relative newbie to copyright, I started at University of Glasgow in 2015. I've found, for example, the book you've both created, The Copyright and E-Warning, A Guide for Practitioners, is a fantastic resource. I found this very useful, along with even the resources on your website as well, the Copyright Card Game. I've used that in workshops I delivered last year to academics, and I found it a great way to get engagement as well, because I know that can be a challenging area. And finally, as well, the Liz Copy Seek. It's a great mailing list, which I'm part of as well. And I think, as Chris and Jane both highlighted, the community is very important, more when it comes to the sharing of ideas as well, and any questions you have as well. And finally, I will definitely try and get SCURL t-shirts for next year. I think that's a must, so we'll definitely work on that. And I'll just check the chat if anyone has any questions. And if not, I will pass over to our next speaker, who is Bart. So if you bear with me, Bart, I'll just give you the hosting rights.
Yeah, just to say, Greg, the question about further details of the workshop for film studies lecturers, that's for Bart to address as part of it. That's really what he's going to be talking about. So we're really pleased to be working with Bart on that.
Definitely, yeah.
So yeah, thank you very much.
Thanks
Wonderful,
very much.
thank you.
Yeah, we'll be here listening, so if there's more
Great,
questions.
please. Yeah, that'd be wonderful.
Yeah.
Okay, Bart, I will just pass you over.
Thanks very much. So first of all, thanks very much for inviting me, Greg. And thanks, Jane and Chris, for your excellent presentation. I'm Bartolomeo Meletti, and as Jeanette pointed out in her kind introduction, I work for CREATE, the Creative Economies, Copyright and Creative Economy Centre at the University of Glasgow, and also for Learning on Screen. And one of the main projects I've been working on for CREATE over the last few years is copyrightuser.org, which is an independent online platform intended to make UK copyright law accessible to everyone. So on the website, you will find accessible guidance produced by leading copyright academics, as well as free educational resources. And the goal of the initiative is basically to help creators, academic staff, students, researchers, cultural artists, practitioners, and all kinds of copyright users make informed decisions on copyright issues. So as Jane and Chris just pointed out during their presentation, during the current crisis, there is a widespread need for more guidance on copyright, and especially on how existing materials like films, music, texts, and so on can be reused for educational purposes. So what I thought would be useful to do during my short presentation is to focus with you on two areas of the law that provides you with an opportunity to lawfully reuse existing materials for educational purposes and beyond. So namely the public domain and the copyright exceptions. And while I do that, I also point you to copyright user resources that address those topics in more detail. So as you will see in most of the slides, there are links to specific pages and resources on the copyright user website. And I'm very happy to share the slides afterwards if you want to find out more information about those topics. But first of all, I think it would be useful to just go through very briefly some copyright basics and basic principles that will also help you understand the role that the public domain and copyright exceptions play in the copyright system. So one way of looking at how copyright works is that copyright as a system needs to strike a very delicate balance, a balance between protecting creative works and allowing the public to use creative works. So in other words, copyright as a system has two main potentially conflicting objectives. So the first immediate goal is to incentivize creativity, the production of new works. And so the way in which the system tries to achieve that is by giving creators a set of exclusive rights that allow them to control the use of their work, and so to make a living out of it. And so the idea is that by making a living out of it, then they will be incentivized to produce new work. But then the ultimate goal of the system is the dissemination of the works produced through the copyright incentive, so the spread of knowledge, the encouragement of learning. And the way in which the system tries to achieve the first objective, incentivizing creativity, which is exclusivity, that's basically is by giving creators the right to say no to other people who wants to use their work. And so you can see how clearly exclusivity clashes with the ultimate goal of the system, which is dissemination. And so the way in which the system tries to strike this delicate balance is by, on the one hand, giving exclusive rights to creators, but at the same time also limiting the nature and duration of these exclusive rights. And this is what I'm going to focus on today. So in particular, how exclusive rights are limited in terms of duration and also in terms of the kind of uses that they can cover. So how does copyright incentivize, protect, creative works and so incentivize creativity? I'll be very brief on this also because Chris and Jane touched upon that already. So, first of all, in order to understand whether your work is protected by copyright, you need to see whether it falls within one of the 8 categories of works protected by law. So literary works, musical works, artistic works, and so on. So if you create a work that falls within one of these 8 categories, then your work also needs to meet 2 protection criteria, which are fixation and originality. And so if you create a work that falls with one of these 8 categories, is original and in fixed form, then your work is automatically protected by copyright. And owning copyright in a work basically means that you own a set of different economic rights. So the right, for example, to copy the work, or to perform a work in public, or to communicate the work to the public, and so on. So, and these are basically the acts, restricted by copyright. So, as I mentioned at the beginning, these are exclusive rights, meaning that the author and copyright owner can exclude other people from doing any of these things, without their permission. And we know that also from Section 16 of the Copyright Designs and Patents Act, which says that copyright is infringed when someone, without permission from the copyright owner, does any of the acts restricted by copyright, so any of the acts covered by these economic rights in relation to the work as a whole or any substantial part of it. So this is in a very brief, in a nutshell, how copyright tries to protect creativity and so incentivize the production of new knowledge. But if you look at that from a reuse perspective, what that means is that, basically in most cases, if you want to reuse an existing work protected by copyright or any substantial part of it, and you want to reuse it in any of the ways, the use is covered by the economic rights, then in principle, you need permission from the copyright owner. But as I said, in order to strike that delicate balance, the law also puts some limits to the exclusive rights. And from a reuse perspective, that basically means that you don't always need permission, to reuse an existing work. So for example, you don't need permission to use a work which is in the public domain because its copyright term has expired, and this is one of the areas we're going to explore today. Also, you don't need permission to borrow ideas underpinning a creative work because copyright only protects the expression of ideas and not ideas themselves. And also, you don't need permission to use a protected work if your use is covered by one of the copyright exceptions provided by the Copyright Acts. So these are the 3 main areas of the law that offers you an opportunity to use existing materials without permission. And in addition to that, you don't need also to get permission to reuse a work distributed under Creative Commons. I mean, that's not a use without permission, but that's a use where permission has been granted by the author to everyone to use the work in certain ways. So as you can see in this slide, each of these bullet points link to a copyright user page that addresses each of those topics in more detail. But yeah, the 2 areas I wanted to explore with you in a little bit more detail are the public domain and exceptions. So for the public domain, I'll try to be as practical as possible. So these are the main rules on copyright duration, right? So copyright in a work usually lasts for the lifetime of the author plus 70 years. So that's the rule for literary, dramatic, musical, and artistic works. So, 70 years after the author's death, his or her works will enter the public domain, which means that anyone can reuse those works as they wish for any purposes, even commercial purposes. So, things like Charles Dickens' novels or Shakespeare plays, Mozart compositions, Van Gogh's paintings, they're all in the public domain. Then for films, you also have the 70 years rule, but you have to calculate the 70-year term from the death of the last to die of 4 different people who are the director, the author of the screenplay, the author of the dialogue, and the composer of the music specially created for the film. So if you want to understand whether a film is in the public domain, then first you need to identify these 4 people, find out whether they all died, and if the last to die died more than 70 years ago, then the film will be in the public domain. Then for more technical categories of protected works, the term is not calculated in relation to the life of the author, but for sound recordings is 50 years from the years in which the recording was made, or more often, if the recording is published, is 70 years from publication. for broadcasts is 50 years from transmission, and for typographical arrangements of published editions is 25 years from the publication of the book. So these are the basic rules that you can find in the Copyright Act. Then, calculating copyright duration can get very complicated. So I've included here a couple of links. One is to the copyright user guidance on copyright duration. And then if you're interested in even more detailed guidance, Copyright Cortex also offers very authoritative and detailed guidance on copyright duration. But I would say that, in addition to the term, life plus 70 years, and so on, I would say that the two main rules that you need to bear in mind when calculating whether a work is in the public domain or not are, first of all, that copyright law is territorial, and so is the public domain. So basically, in each jurisdiction, in each country, there are different copyright laws and also potentially different copyright terms. So that basically means that, a work might be in the public domain in the UK, but not in another jurisdiction like the US, or vice versa. So one example of that is Sherlock Holmes. So Sherlock Holmes stories, were written by Conan Doyle, who died more than 70 years ago, which means that all Sherlock Holmes stories are in the public domain in the UK. But a few, I think like 5 or 6 of the, the short stories with Sherlock Holmes were published after 1924. And for example, in the United States, most works enter the public domain 95 years after publication. So, that's one example where you have, all the Sherlock Holmes canon is in the public domain in the UK, but a few stories under the 95 years after publication rule will still be protected in the US. So that's something to bear in mind. And the second thing to consider is also that a reproduction or a recording of a public domain work may qualify for copyright protection itself. So say, for example, a music composition like Beethoven's or Mozart's compositions, they're all in the public domain. But then if you want to reuse a specific sound recording that was published less than 70 years ago of those compositions, then you would still need to clear rights on the sound recording. What I thought might be helpful in the next slide, I've included a few links to sources of free-to-use content, and some of those also offers, free-to-use recordings and reproductions of public domain works. So on Wikimedia Commons, for example, you can find a lot of paintings that are, photographs of public domain paintings that are free to use. And for music, there's Incompetech and so on. So you can, play and explore that list later once you receive the slide. So that's the first area of the law that I wanted to briefly mention. And the next one are copyright exceptions. So copyright exceptions are cases in which, under certain circumstances and for certain specific purposes, you can use protected works, even substantial parts of protected works, without permission from the copyright owner. And the reason why the copyright system allows these uses is because the legislator considers them to be socially, culturally, politically, or economically beneficial. So things like education, the preservation of our cultural heritage, research and private study, and so on. And in the UK, there are two main types of exceptions. There are certain exceptions that explicitly allow the use of the entire copyright work, but most exceptions in the UK are dependent on the notion of fair dealing. And one important distinction to make is that fair dealing is different from fair use. So fair use is an American doctrine that only applies in the US and a few other countries that have similar provision. And while fair use is a much more open-ended and flexible exception, in the UK we have a list of exceptions, and basically your use, in order to be covered, needs to fall under one of those exceptions. So what I thought, there are quite a lot of exceptions in the UK Copyright Act, which are relevant, for the education sector, but I picked a couple which I think are especially relevant right now, in the current crisis, especially for online learning. So basically exceptions that you can rely on potentially, also to adapt your copyright policies in this new context. So the first one I wanted to mention is not a fair dealing exception, and is Section 34. So Section 34 of the Copyright Act allows allows teachers basically to perform, play, or show a work in the course of the activities of the educational establishment. And if you look at the bits in bold here, the main application criteria are that the audience must consist only of teachers and students at the educational establishment or other people directly connected with the establishment, that the screening or performing or playing and so on is in the course of the activities of the establishment and also for the purposes of instruction. So this, is the exception that allows you, for example, to screen an entire film, also without a license to your students if the screening is for the purposes of instruction and the audience only consists of teachers and students at the educational establishment. At the moment, there is a very lively debate on whether this exception would also allow to screen films and other works online, and there are conflicting interpretations on that. I mean, we can maybe discuss that in a bit more detail during the Q&A, but basically, some scholars argue that this is only an exception to the public performance right. And so if you screen the film online, as that would involve electronic transmission, that would not be a public performance, but will be a communication to the public. In my view, there is also another way to look at this exception. And basically, if the screening happens live at a set time and is only accessible to an audience consisting of teachers and students, in my view, that the discrete group of students will probably not be considered the public. And so that kind of use will not be, a court will not be considered, would not consider that use a communication to the public. But anyways, that's one exception that I would consider. And then, the Copyright Act also, as I said, provides a number of fair dealing exceptions. So I've listed here on this slide the exceptions that I believe are the most relevant for the education sector. And each of these link to copyright user pages that specifically provide guidance on those exceptions. So I would say the most relevant ones for the education sector are probably the first two, illustration for instruction and research and private study. But then it's also very important to be aware of criticism, review, caricature, parody, and pastiche, and quotation. These are very enabling exceptions that, for example, are not limited only for non-commercial uses, but also allow commercial uses of protected works. And so these are particularly, potentially very enabling for online use and also, for students who may want to, reuse works and like create mashup videos, for example, and then make their videos available online. But yeah, the one exception I wanted to focus a bit more on is illustration for instruction. So that's the provision of the Copyright Act. And, the next slide, I provide a summary of what I believe are the main aspects to consider of this exception. So the first two bullet points are the advantages, I think, offered by this exception compared to Section 34. So the first advantage is that illustration for instruction provides an exception to all economic rights, so not only to the public performance right, and so it is also an exception to the right of communication to the public. So you don't have that issue that I just briefly mentioned in relation to Section 34. So potentially, if your use is covered by illustration for instruction, you can also make your work available online. But then again, here you need to consider territoriality, as I mentioned, in the context of the public domain, which basically means that you can make available a work created under illustration for instruction online in the UK, but then if your work is also available in countries that don't have similar exceptions, that may expose you potentially to a risk. But I would say, the risk, as most countries do have educational exceptions similar to illustration for instruction, the risk of getting sued for an educational use online, especially if the use happens through a protected VLE, will be extremely low, if not negligible. And the second, advantage offered by this provision that you don't have with the Section 34 is that, as you can see here in point 3, this exception can't be overridden by contract, which basically means that if the terms and conditions of a service, prohibit you from, for example, using a work for educational uses, then if your use is covered by illustration for instruction, you can ignore those terms and conditions because those would be unenforceable. So that's the case, for example, with the Netflix shows. Netflix terms and conditions only allow you to use their shows for personal use, but if your use is covered by illustration for instruction, in principle, you can ignore that. Then other conditions that are not present, I mean, further limitations that are not present in section 34 are sufficient acknowledgement, but that's not very onerous. So, you know, you need to credit the author of the work that you're using. And yeah, it's important to notice that you need to credit the authors, not the copyright owners. And also that you can only rely on this exception for non-commercial purposes. Although again, it's important here to note that the non-commercial purpose relates to the dealing, not the status of the organization. So things like, you know, giving an internal seminar in a for-profit organization may well be covered by illustration for instruction. But the main, limitation in a sense of this exception is that it is a fair dealing exception. And, so basically in addition to all these conditions, your use in order to be covered by the exception also needs to be considered fair. And the issue with fair dealing is the same that we have with other concepts in the Copyright Act, like originality and substantial part, which is that they are not defined in the statute. So you won't find a definition of what fair dealing is in the Copyright Designs and Patents Act. So what you have to do in order to understand what fair dealing is to look at court cases. And so if you look at case law, basically there are a number of factors that usually courts consider when assessing whether a specific use is fair or not. So that's the list. So they will consider things like the amount and importance of the work taken, how much of the work you're using in relation also to the rest of your work and commentary and so on. But I would say the most important factors usually considered are excessive use in relation to the purpose. So, the fact that you should only use what you need in order to achieve your purpose. So, in the case of illustration for instruction, you should only use what you need to illustrate your point for teaching purposes. And also whether the work that you create, like a teaching resource, for example, is commercially competing with the claimant's work. Now, the issue that we have then with illustration for instruction, as well as with most of these fair dealing exceptions listed here, is that apart from criticism review, which was introduced in the UK in 1988, the other 4 exceptions have been either introduced for the first time or amended in 2014. And so, we don't have any court cases that specifically address these exceptions in particular. So in this context, it's very hard to determine the scope of application of these exceptions. You can look at the law and see what the application criteria are, but then you will never be sure how a court would consider fair dealing in the context of these specific exceptions. And so that's why, one way basically to address this issue is by talking to the beneficiaries of the exception directly and find out what they consider to be fair. So this is the initiative that Jane and Chris mentioned before, and that we are about to start, also in collaboration with Learning on Screen, the University of Kent, the City University of London, and Create. So the initiative is inspired by a very similar initiative conducted in the United States over the last 15, 18 years by the American universities. So the first link there, you can find more information about that. So what they did, basically, they developed a series of codes of best practices in fair use, which is the sort of American equivalent to exception. So they talked to various different sectors and had them to deliberate on what they thought was fair practice in their sector. And then they came up with a number of codes that outline principles on which creators, teachers, and so on can rely on when they want to benefit from an exception. And what we're planning to do is basically to do the same thing in the UK. And there are 2 main projects that I wanted to briefly mention, and then I'm happy to discuss in more detail. So the first one, which is the one I just mentioned, so with Jane and Chris, we're going to focus on teachers and illustration for instruction. And so the idea is to carry out a series of workshops with teachers from different subject areas and have them to deliberate on what they consider to be fair when using existing materials for teaching purposes. And so we will start by talking to film studies academics. So we have our first workshop on the 30th of June, and we will probably also have a second one also with film studies, because this is in very high demand. We are receiving a lot of requests to participate. So on the following Tuesday, we'll probably hold the second one. And so, yeah, so this workshop will discuss and explore the teaching practice of film studies teachers. And at some point, basically we will, based on that discussion, we will come up with principles and fair practice criteria that, teachers in that area of study can rely on to benefit from illustration for instruction. And very briefly, I also wanted to mention that with CREATE at the University of Glasgow, in collaboration with EFIR at the University of Amsterdam, we're also doing a very similar initiative in relation to documentary filmmakers and immersive heritage practitioners. So again, we will be carrying out, as part of a Horizon 2020 project called Recreating Europe, a series of workshops that will lead to the production of codes of fair practice. Right, so I think I'm probably running out of time. So the last two slides just point you to a couple of useful resources, especially if you teach copyright or provide training to colleagues. Is The Game Is On, a series of educational videos on copyright accompanied by educational materials, which is all distributed under Creative Commons and free for you to reuse and adapt for your own teaching. And also that at Learning on Screen, we offer a number of copyright courses. The next one is on Tuesday and is the Game Is On session. So basically it's a short session demonstrating how you can use the Game Is On resource in copyright teaching. And we will be announcing new dates soon for the other courses as well. Right, so that was my presentation. Thanks very much for listening. I'll stop sharing my screen if I can.
That's great. Thank you very much, Bart. That was fantastic. Thanks. And I think your codes of fair practice have highlighted what a expansive area copyright is and how much it actually has to cover, because you have the duration, you have the fairness factor, and of course, as you touched on as well, you have all the copyright exceptions, which I find, even prior to the pandemic, I found I was having to utilise them more often when dealing with academics, for example, in terms of illustration for instruction. And you highlighted as well, of course, the section 34 in relation to film sharing, which I think, as you said, there's a lively debate, and it's been interesting to see how that's been discussed as well. And I think, as you said, it's the communication. So you even have the factors of if an academic is delivering a distance learning course and they're based in the UK, if it's being communicated to, say, America, for example, you have those factors to consider as well. And I even wonder if even, for example, other exceptions might be useful. Now, I don't know, like, for example, section 30 in the quotation instance, so that might just be more applicable if you're trying to just communicate, if you will, excerpts of films. So yeah, it's an interesting area. Yeah,
definitely. Yeah, no, quotation is another very enabling exception. I didn't have time to touch upon that, but the Fair Practice Initiative will also cover quotation. So basically, the whole idea is that first we will have a discussion of what constitutes fair practice from a teaching perspective, in a sense, kind of regardless of the law. And then based on that discussion, a team of legal experts will try to see whether those kind of practices might be covered by different exceptions. So one might be, well, illustration for instruction, but, for other uses, maybe quotation, like section 30, may well be a better option.
Yeah. And forgive me, but I've got a question here from Jill in the chat. Does the group believe that the illustration for instruction can be used in the VLE? Does this count as one copy or more as it gives access to many users?
So what was the question again?
It was, does the group believe that illustration for instruction, so section 32, can that be used on the VLE?
Yes.
Does this count as one copy or more as it gives access to many users?
Yeah, I would say, it can definitely be used on a VLE, and even if you give access to many users and to more copies, that's not necessarily, an issue with section 32, because, section 32 is also an exception to communication to the public, which also includes the right to make the work available, in a way that, people can access the work at the time and place of their choice. So basically to make it available via the internet. So if your use is fair, and, meets the other application criteria, yes, I would think that is a perfectly acceptable use in the illustration for instruction.
Excellent. No, thank you, Bart. And just one more, I'll get a couple more questions. Just one more. It's Deborah. Are Learning on Screen copyright courses accessible to non-members?
Yes, they are. I think, for now, the courses are free for members, and there is a small price of cost for non-members. But yeah, anyone can sign up to the courses.
What I'll try to do during my presentation is to perhaps move from the field of teaching and enter slightly into the field of research, even though, you know, this is a rough subdivision, both because research and teaching are tightly connected and because the presenters before me touched upon both aspects. But I think that the main focus of my presentation is on well, on a new famous or infamous, depending on the point of view, but certainly hotly discussed European directive in the field of copyright. And what does it mean for researchers in the UK after Brexit? Because you know that the question of what will be the impact of EU law, including EU copyright law, in the UK in the future is a relevant one. So we will, what I'll try to do is to give you an overview, a very brief overview of what this new European directive is, what it does in general in Europe, and what it will do, if anything, in the UK, and what does it mean for the future relationships between, in copyright terms at least, between UK and EU, because research will happen anyway, and collaborations between UK and European universities will happen anyway, hopefully. But obviously the fact that we may be in two different, we may be governed by two different copyright frameworks will have an impact on that. So I will try to address some of these issues. And I will do this focusing in particular on one specific exception on which I've been doing some work recently, which is the text and data mining exception. So first of all, some key points about the directive, just to give you an overall understanding of what we're talking about, in case you're not too familiar with it. It is, well, Directive 2019/790 on copyright and related rights in the digital single market. And the overall aim, very ambitious, is to make EU copyright law fit for the digital age. It is a rather complex instrument made of 32 articles and 86 recitals. The recitals are like the preamble, are the parts that are supposed to explain what the main articles are. So quite a lot of explanation necessary here. It is a directive, so it's not directly applicable in national law, but member states have to transpose, or to create a law that applies the principles of the directive into national law or domestic law. And we have 24 months, member states have 24 months to do that. It does a number of things. Importantly, I think, especially for us here today, it introduces a number of mandatory exceptions. Now, in the EU, this is very important, the fact that they are mandatory, because so far the main directive that has, so to speak, harmonized the exceptions in the EU is the InfoSoc directive of 2001, but the 21 exceptions listed in that directive, some of which has been discussed earlier today, are not mandatory. So here, the idea on the one hand is to create a level playing field everywhere in the European Union, so that the same exceptions apply in the same way, so that some of the problems that have been mentioned before, for example, the example Bart gave on distance learning, can be easily overcome. However, what has been done in 2001 was not to make them mandatory. So in principle, every member state could pick a different combination of exceptions. So the fact that today they are mandatory is very important. Obviously, only some of them are present in this list of mandatory exceptions, but the text and data mining exception, or better, exceptions, because we have two, Article 3 and Article 4 are there. Again, very interesting in relation to what has been said before, digital and cross-border teaching exception, Article 5, and an exception for the preservation of cultural heritage. It does a number of other things, the directive. For example, it clarifies that, this is again in relation to text and data mining, that an exception, the only exception I lied to you, or in the 21 exceptions of the InfoSoc directive of 2001, there is one that is mandatory, Article 5.1 for certain temporary acts of reproduction. So this directive clarifies that this exception still applies to text and data mining when relevant. It clarifies that broader national exceptions adopted on the basis of the acquis, so the acquis is the term that we use to refer to the body of EU copyright laws, directives, regulations, and decisions that have been enacted so far. So the exceptions that have been created under the previous directive, let's say, are still valid. So this is, or could be, quite relevant for the UK, because it means that the UK text and data mining exception, which, as we will see, it's slightly different from the new European text and data mining exceptions, will survive, will still be compatible with text and with, you know, the new text and data mining European framework. But the directive does more. It clarifies, is also quite interesting, I think, that the digitization of works of visual art that are in the public domain remains in the public domain. That's another quite contentious issue in the field of copyright and cultural heritage institutions. I've done some work on that in the past, and I know how different the views and the needs may be in this field. And then the most, again, famous or infamous of the rules, that the one that you probably have heard about. So the protection of press publications concerned online uses, something that in the past was referred to as the link tax. Perhaps you've heard that expression. And the Article 17, former Article 13, on the use of protected content by online content sharing service providers, also known as filtering obligation. And then there is a whole chapter on fair remuneration in exploitation contracts for authors and performers, which somehow try to compensate or to reinforce the position of authors and performers in the face of the other rules that we have seen so far. So will any of this matter in the UK? No, it will not. And the reason is that the deadline, if you remember, I told you that this is a directive, and in order to become effective, it has to be transformed into national law. So the UK Parliament, or the government on their behalf, usually creates a bill, and the bill is approved, and then it takes the force of law, and then it is in effect into the UK. However, the UK left the EU in January, and the implementation period will end on the end of December, and which is before the term that the directive gave to member states to implement its rules. So it means that the UK is under no obligation to implement any of what I just told you, which may raise the first question: why did you tell us in the first place? But hopefully, if I'm successful in my aim, I will, I will explain it to you towards the end. So the fact that the UK is not under any legal obligation to implement the directive, it doesn't necessarily mean that the UK will not do that on a voluntary basis. So it could be possible that the UK will decide to implement perhaps not all of the directive, but certain parts of the directive, in order to maintain the so-called level playing field with the EU, in order to favor cross-border trade and collaborations, and to favor cross-border research, etc., 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 such as in the case of text and data mining. But again, online teaching would be a very relevant one. So the question becomes, will the UK do that? Well, obviously, it's difficult to predict what will happen in the future. We can only know or base our judgment on what has happened so far. And what we know is that the current government asked about this specific question, answered on relatively recently, the 21st of January 2020. Well, the first part of the answer, it's what I basically summarized to you. I go to the part in bold. Therefore, the United Kingdom will not be required to implement the directive, and the government has no plans to do so. Any future changes to UK corporate framework will be considered as part of the usual domestic policy process. So as far as we can tell, and again, this does not mean that, things may change in the future, but there's no really at the moment, any plan to implement any parts of the of the European directive that we have analyzed. Which, it's we'll see. It has pros and cons. It's a bit surprising because this directive has been harshly criticized by a lot of people in the UK at the institutional level, except that the UK was a big supporter of this directive in Brussels. So that is somehow it raised a few eyebrows because it appeared like a very sudden change of mind. We'll see. Anyway, what is also important to keep in mind is that the whole body of EU corporate law will be considered retained law. So all the all the legislation, all the UK legislation that has been enacted so far on the basis of previous EU law will remain in effect and will remain valid, but it can be changed in the future. However, there will be no sudden change, when we move to a UK corporate framework that is not bound at all by EU rules. Change will happen likely in the future. So, given this framework, then let's have a look. I think it's a quite interesting and hopefully useful exercise to look at the text and data mining exception, because we have a text and data mining exception in the UK Corporate Design and Patent Act, section 29A. Now, finally, we have a mandatory EU text and data mining exception. Actually, we have two of them. We will have to be prepared because we are about to enter a period of time in which activities carried out in the UK will be governed by the UK text and data mining exception, and activities carried out in the EU member states will be regulated by the EU text and data mining exceptions, and they are not fully aligned. So we will find, especially in the case of research collaborations that involve the UK and European universities, we will find often in this situation where certain things can be done and certain other things cannot be done depending on where you are. So let's see briefly what are the similarities and the differences of these two exceptions. I have a brief summary here that briefly sets out what I'm going to do very briefly. I will look at the definition, at the scope, at the beneficiaries, the relationship to contracts, the relationship to technology, well, there should be a point 6 storage, but it's not in the summary slide. It is in my content slide. Don't worry. So regarding content, here I report both. So Article 2, Copyright Digital Single Market Directive. It's the definition, and then the definition used by the CDPA. Two different definitions. Both seems to be broad enough to cover most of the uses. So no particular problems here. Problem starts with the scope. Even though in this case the scope remains, we could say it's aligned. So both in the UK and in the EU, the text and data mining exception is an exception to the right of reproduction. Now, to give you an idea, in the US, fair text and data mining, it's considerably, it's generally considered fair use. But fair use, it's a much broader exception. So we don't have these problems of, is it an exception to the right of reproduction, or also to the right of communication to the public, or also to the right of distribution, or also to the right of creating adaptations. In the US, we don't have this problem. In the both EU and UK provisions, the text and data mining exception is an exception only to the right of reproduction. Why does it matter? Well, it matters because the results of text and data mining could be a copying part of a protected work, and we know that 11 consecutive words may be reproduction in part, so an infringing one. So let's say if you train a model for natural language processing and you train model, the file, the database, you have a sequence of 11 consecutive words, then in that case, making that model, it's covered by the exception, but you cannot distribute that model. So you cannot, for example, I don't know, publish it, or you cannot put it into, in a cell phone. You have developed that application as part of a, translation from English to, say, I don't know, German. So you could not do any of these acts that are not covered by the right of reproduction, but that goes a step further and are forms of distribution or communication to the public. Similarly, if the results can be considered as an adaptation, and in the States we have cases where text and data mining the web to create thumbnails is being considered a form of fair use. Well, this exception in this case, it's of no avail, because thumbnails will be likely considered a form of derivation, adaptation, and therefore the exception is not available again. I'm giving you these details, and maybe it's too technical, but the main message here is that instead of having a broad and flexible approach as we have it in not only in the state is the usual reference, but we have it in the States, in Canada, in Singapore, in Japan, in South Korea, in all the countries that you can think of that are, the competitors in terms of innovation of the UK and in the EU, we tend to have broader approaches, more flexible ones. Whereas in the EU and also in the UK, we tend to have a much more narrow approach to these cases. So here we only have an exception to the right of reproduction instead of to copyright as a whole. Beneficiaries, again, we don't have this limitation around the world, but we find it in both the UK and in the EU. However, in this case, there is no alignment. So I told you that there are two text and data mining exceptions in the EU. One is, I'll tell you in a moment why there are two, but Article 3 applies only to research organizations acting for research purposes, whereas Article 4 applies to anyone for any purpose, but it can be limited by contract, whereas Article 3 cannot. Whereas in the case of Section 29I CDPA, the beneficiaries, or the scope is for non-commercial research. So here, as you can imagine, there will be scope to discuss what kind of activity is this specific activity. Is it non-commercial research? Is research organization for research purposes? Because obviously this will affect the way in which, let's say, a consortium working across 3, 4, 5 European countries will have to address this issue. It also poses a number of questions connected to why do we exclude individuals and micro and small and medium enterprises, industries, why they cannot benefit from this exception, and why purposes other than research, such as, I don't know, journalism, criticism, review, why are they not covered? And this could certainly represent a contrast with fundamental rights, because it seems to be an unreasonable discrimination in terms of purposes. Another important aspect here is that only work for which you have lawful access is covered. So that's another important precondition. Again, all of them are not cannot be limited by contract, except for Article 4 of the European Directive, which is characterized by being broader, but having the possibility to be opted out. The relationship to technology is much more complicated. I probably don't enter into the details, but happy to discuss this further. The idea is that from my point of view, there is an obvious contradiction, because if you express a condition, exception not available, and you express this condition in human language or in legal language, then that's not enforceable. However, if you express the same condition in computer code, like through encryption mechanisms or to, for example, even metadata, one could argue, then this condition suddenly becomes enforceable, or it's a bit more complex. You cannot break that that technology if it is effective. You could request in the UK IPO to order the right holders to make a copy available to you if you have access, if you're entitled to access that copy via an exception. There is a mechanism that over the past 10 years have been used twice only because it's too complex. It's not the fault of the UK IPO, it's simply the legislation, it's too complex. And I think that both attempts failed. Storage, this is something that is only covered by the EU exception. I think it's very important because it allows the storage of the material that has been used for text and data mining, and this is essential for verifiability purposes. Perhaps I didn't make it very clear at the beginning, but text and data mining is not just the new exception that we have here today, but is basically a technology that is the gateway to everything that we do now, or not everything, but almost everything that we do nowadays in the technological field. It has endless applications. It is at the core of data-driven artificial intelligence applications. So to say that you cannot do this and that, or you can only do that under certain conditions, has a strong impact on innovation. But this aspect of storage is particularly important because it ensures that the results that we obtain under the mentioned conditions can be verified and eventually replicated, which is an essential aspect not only for scientific purposes. So this is for the exceptions and limitations. I have a couple more slides where I try to go a step further and try to discuss why this matters so much. I only have a couple of minutes left, so I will go quite quick through them, but I think they help to understand why this is so important. And it has to do with the idea of ownership of data. Here I'm referring to non-personal data. Can data, factual data, information be protected? And despite of what often is being said, copyright law, especially copyright theory and often copyright law when it is properly devised, is clear to say that principles, facts, data as such, information, methods of operation, etc., are not protected by copyright. You can find this everywhere in international treaties and also in national legislation, because these are the bricks, the basic bricks of human knowledge. If you say that a certain datum or a few data can be object of protection, it means that no one can, let's say that the temperature that there is in Glasgow today is object of property. Well, that means that no one can reuse that information. So obviously there needs to be a line to be drawn between what can be used to create new information and the incentive that has been mentioned before, that has to be given to people to create. And this line here, it's been drawn along this how to say, in this way. What is original, so your original expression, it's protected, but the basic bricks of knowledge, data as such, information, are not. There may be other areas of law that offer limited protection, such as trade secret, for example. But this is a limited approach. It's not a full-fledged property right as copyright. Obviously, the things are a bit more complex. One thing is for data as such. Another thing is for data contained in databases. And here in Europe and in the UK also for the future, we have this sui generis database right, which effectively protects a collected data, but only substantial amounts. So this is something we have to keep in mind. Happy to discuss this further, but I don't want to make things too complicated. And then we have data contained in works. So, no one objects to the fact that the latest novel, and I think at some point I made Harry Potter as an example, and then it's just always Harry Potter, but it could be any other novel. No one has, puts under doubt the fact that, if you photocopy the book, or if you want to create a film from the book, or, all these kind of uses, they, are covered by copyright and should be authorized. But if we are using the novel just to extract syntactic information about the English language, so we're not using the novel as a novel, but we're using it as basic information for, a completely different use. We are not copying the literary work. We are just looking at information contained in it. Well, logic would suggest that this is not protected. However, because of how copyright laws, especially in the EU, have been designed, including the UK, now at the end of the day, you need to make a copy to extract this information, which means that most likely you need an authorization, which may be contractual, a license, or maybe statutory, an exception, such as the text and data mining exception. But you need it. So this is quite important, and we have to understand the implications of this. And the implication are that and this is answer number 2, answer number 1 is the one that I just gave you, is data owned? Well, despite of what corporate theory says, at the end of the day, often it is. And why does it matter? It matters because it will impact how, the future of knowledge creation in a way that far exceed what corporate legislator usually thinks in terms of policy consideration. Often they, when a new law in the field of corporate is being discussed, we are looking mostly at, protecting the authors, even though often, it's not really the authors, it's the publishers, and what about the platforms? And sometimes, not very often, we remember of the users who should receive some protection. But these are much broader questions of innovation, industrial policy that I don't think they're fully understood. By designing the laws in the way that we are doing today, we are basically designing the technology that will govern us for the next decades. And I'm not sure that the way in which we are designing them, it's the way that we would do it if we understood the deepest implications of it. So concluding, what then for the future of UK copyright and text and data mining? Well, in principle, in the UK, there will be space in UK copyright law to develop along a more innovation-friendly direction, for example, implementing a broader text and data mining exception, or even a flexible copyright limitation, which is currently not possible due to the, to the Article 5 of the InfoSoc directive. But whereas this is technically possible, it seems more likely that the future of UK copyright law will be caught between the reasons of regulatory competition and a level playing field with the EU. So it will largely depend on what the next relationship between the UK and EU will be. It's hard to tell how this will develop. However, certainly researchers and individuals and users and their needs have been consistently ignored or only marginally considered when this decision has been taken. And it would be good if on this occasion they became the protagonist. So this is the end of my presentation. I have a couple of, well, thank you first of all, and a list of useful resources. that we have collated or created in projects connected to what we do, and a couple of articles I have written, quite an elegant self-promotion. I hope that you find this interesting, clear, and thank you very much again.
Thank you very much, Thomas. That was fantastic. Thanks. I loved how we explored the copyright from, of course, a researcher's perspective, the relationship to contract, and of course the technology and imbalance it creates as well. I liked how as well we also explored storage and even who owns the data and some copyright theory in relation to facts, etc. But Thomas, if I may, we've got a couple of comments in the chat, if you don't mind exploring them. So if you bear with me a moment or two. We have a comment from Chris. So it was discussion about text and data mining. Going through these issues with researchers gets very complex and involved because of the different layers of rights. And as with most things copyright related, it often comes down to risk management.
Can I, sorry, Greg, can I jump in and add something else just to the end of that comment? So it's more, it's also related to, Thomas, you've mentioned the sui generis right, the database right, which potentially could disappear from UK law because it's an EU right. And I think those of us who are responsible...
It will stay in the withdrawal agreement as it is nowadays. It will stay.
It now actually says it will stay. Okay.
But it will stay only for... So it will not be mutual... Sorry, it's very complex, and I shouldn't say I should go back to verify this in detail, but it seems to me that the idea is that it stays, but it will not be mutually recognized between UK and EU unless you are residing in so if you are EU national, in order to benefit from the UK sui generis database right, you have to be based in the UK. So there is a residence requirement. I think that this is how it stays now.
Yeah, so I think it's another complication to an already complicated area. And I think I'm also looking at Charlie's comment around personal data. I think what we see for those of us who are working with academics to work out what the right thing to do is, it's a really complex picture to pull together all the legal aspects of working with producing data and using data. And I just wonder what can actually be done from a sort of an advocacy and an explanation point of view to turn this into language or guidance that a researcher would be able to make use of, and to say, okay, I know what to do, I know how to make my research available.
I think that's the core of the question. So I think two things. One, I have noticed everywhere a quite significant and to some extent surprising disconnect with. So let's start. What can we do from, as start where mostly or many of us are based in research institutions or universities, and I can say that there is a strong disconnect between library, faculty of law, and legal team, so technological transfer office or the legal department at universities. I found that often. I obviously cannot say for places where I haven't been, but I noticed that this happens quite often. And perhaps a first step would be, and we tried to do this in Glasgow to some extent, together with Greg and also with other colleagues in the information team, to talk together because often things go in different ways. I noticed, for example, that a lot of open access questions go to the library, and the library often, speak for Glasgow, finds themselves a bit, obviously there is a lot of expertise there, a lot of knowledge, but at the same time, there is no in-house lawyer that can reach to the deepest implication of some of the questions that are received, because sometimes the researcher comes with extremely complicated questions connected to a very intricate contract that the publisher wants him to sign or not. So there may be synergies by combining the expertise of the libraries in the field of open access and open science with the legal knowledge, more academic that you find in the law school, for example, you know, in the case of Glasgow, you know, we have the Create Center, together with the much more practical knowledge of the internal functioning and dynamics of the university with the legal team. So I think that, you know, that synergy is a first step that could prove very, very powerful. And then in terms of making, you know, how do you translate this into information that can be easily digested by researchers who probably, you know, if they could choose, they would happily ignore all of this, right? You know, if you're a researcher, except then a researcher in the field of copyright, you want to do your research. You don't want to have to worry about, you know, can I use this? Why should I care? Why should I, you know, that's not part of your research. So to make it understandable, it's very difficult. I think, you know, the only sensible approach is a graduated one to explain researchers that, you know, with some of the educational work that, you know, you have been doing as well, what are the basics? But, you know, we cannot expect researchers to become experts. We have to teach researchers, you know, maybe the most important thing is to teach them when to seek for, you know, professional help. And hopefully we're able to offer this professional help within the university. That's probably the main one of the main things to do from my point of view. But it's a very complicated. So, you know, there may be many other things that may make much more sense.
That's wonderful. Just to say,
thank you.
sorry, thank you very much. I do apologise. I see there's a few more comments in the chat. Unfortunately for me, we'll now get on to our last speaker, who is James Bennet. So James, I'm just going to make you host.
Give you a quick update on CLA's licensing and services. So I'm head of rights and licensing at CLA, and I'm responsible for managing the value and relevance of our blanket licenses, and particularly, well, I've been doing particularly quite a lot of work recently with the higher education sector. So I'm going to just go through a few slides. It shouldn't hopefully take too long, because of course, you know, things are moving quite quickly at the moment in the world of licensing, and we are trying to react to the you know, the really extraordinary circumstances we're in. So I didn't really know what I'd be presenting when I agreed to talk today. So just to make sure that I advance my slides. So just a really brief thing about CLA, Copyright Licensing Agency. We're a not-for-profit company. We're limited by guarantee, and we're owned by publishers, authors, and visual creators in the UK. And we're a licensing body. We offer, mainly we offer collective blanket licenses that permit limited copying from almost all books, magazines, and journals, and a large number of websites. To do that, we also have international relationships. So users in the UK can copy from works from about 38 other territories as well, and vice versa. So works get copied overseas under agreements through other organisations. We've got about 100 employees in London and Edinburgh, and what we do is we sell the licenses, we administer them, and we also collect data, sample data and census data on the usage of the license, which we use to inform the distribution of the license revenue to our customers. Just looking at the question, the slides, I'm happy to make my slides available anyway. And yeah, we're funded by taking a subvention on the license fee. Just moving to the next slide. So there's a couple of things I wanted to talk about today. The first thing is looking at what we've done over this spring and summer to provide some support for the higher education sector during the COVID-19 crisis, and what we might do in the future. And I also want to give a quick update on the EHES service, which is run by the British Library on our behalf, and we can give an update on where we're at with that. So first of all, what challenges were with the education sector facing? So when we were looking at this in March and early April, we were finding that universities were closed, university libraries were closed, students were sent home, including overseas students being sent home overseas. So, you know, a major crisis. And we also the British Library were unable to offer their EHS service, certainly for scanning from print. All teaching staff were trying to work from home, and everybody, as Jen and Chris about, was suddenly having to work out how to do online teaching and learning, and grappling with copyright issues. So we looked right across the sector at what we could do to help. We also had some specific requests from the Copyright Negotiation and Advisory Committee, on which Jane and Chris are members, representing Universities UK and Guild HE. A couple of major things they were asking us for: could we provide some increased access to the digitised extracts that were held in our digital content store by removing the requirement to own an original? And also, could we do something about extending the extent limit, which is currently 10% of one chapter that can be copied in education, higher education? So what did we do? We looked at what we could do, and we discussed it with our members. So ALCS representing authors, DAX and Pixel representing visual creators. We also spoke to all the major academic publishers via our working groups and the trade associations who kind of co-own us. So we really we got a lot of positive help and support from the rights holders, building a consensus on what we could do. And just before the Easter break and just after, we did announce what we could do, and we agreed that we'd be able to extend the terms of the CLA higher education license till the end of June, which is coming up soon. So what were we able to do? So we were able to, first of all, remove that requirement that the institution must own an original. So this applied to all the works covered by the license, and it enabled a couple of things which weren't normally available, which we hope were helpful. They enabled, if an institution found a PDF extract in the digital content store in the DCS, but they didn't actually own an original, they couldn't very easily acquire an original at that point. So we said, that's fine, you can just use it on a course. And also it enabled academic staff to scan extracts from their own personal copies of works. And we've found that in some cases, academics have actually taken photographs of their mobile phones, stitched these together and put them on the VLE in an emergency for teaching. And we said, yep, that's fine, that's something that you need to do. The second thing we did is we were able to increase the extent limit of what could be copied under the license up to 30% or 3 chapters of work, where a publisher had opted in. We got about 130 publishers opt in, including almost all of the major publishers that get copied in higher education. We said, yep, you can do this whether the institution or an academic owns the original. There was a restriction that there had to be no digital edition available through commercial channels. So if you could have bought an ebook, we weren't able to let you copy the extra amount. And we did require that this was done through the DCS, so that we were collecting data on what was used, and that it was easy and clear to remove those extra bits that were copied under the license extension at the end of this period. Over the period of the extension, we found that 54 universities, that's about a third of them, used this for about 167 different titles, and we had usage from works from about 60 different publishers, and the extra amount amounted to about 4,000 extra pages. So that was kind of a fair amount of use, but because of the time of year and some of the restrictions, maybe it's not been as helpful as everyone thought it might have been. But this was something we were able to do sort of in the emergency period right at the beginning of this pandemic, and we have been looking at what we could do after the end of that period. So we haven't been able to get agreement with rights holders to extend those provisions beyond the 30th of June. We're actually sending out an email today to all of our license coordinators to confirm that, and we've been in touch with CNAC to discuss it too. But we are looking at a number of ideas that could help in the short and the long term to solve some of the issues around access and reuse of a broader range of content. So one of the things we can announce already is that we're going to be offering a new help desk service for copyright clearance and copyright fee paid use to support institutions in meeting the challenges of the next academic year. We're going to be revealing more information about that in the coming weeks, but it's basically going to be providing person time somebody who can help you with some of the issues and cases where at the moment CLA doesn't really provide a solution. But there will be other things that we are exploring with our rights holders and with the CNAP group. So it's not the only thing we'll be rolling out, we hope. But we're looking to the longer term to see what we can do to help for the whole of next year and possibly the year after. So that's about all I can really say for now in terms of the licensing. So yeah, James just clarified that the license reverts back to the normal limits in terms from the 1st of July of this year. And we do hope that the normal license terms and limits are still very useful in the current circumstances. You can make works available on the VLE up to the 10% or 1 chapter extent limit, and it doesn't matter where the students are in the world. It doesn't rely on an exception, so it's not territorial. They can access the content online and get on with their online learning. The other thing I wanted to just update you on is the British Library eHealth service. So just not sure how many people will be familiar with the service, but we hope most people are. It's the enhanced higher education supply service operated by the British Library, but managed by CLA in that we do the invoicing. Provides a copyright fee paid document supply service, and it also provides an outsourced scanning service where the institution and the British Library both hold a copy. Where it is just outsourced scanning, there's only a service charge paid. The British Library will provide high quality OCR scans with, in normal times, they would have guaranteed a 48-hour turnaround. And we've integrated eHealth into our digital content store through the API so that it's all rather seamless when you use it through that service. And we have a lot of customers using eHealth all the time. However, as soon as everything shut down, eHealth had to be suspended because the Boston Spa site on which the scanning takes place had to be shut completely. They were offering a document supply service from digital only, prioritising NHS requests, but now we've been told by the British Library in the last couple of weeks that they are reopening Boston Spa. They're trialling doing the eHealth scanning service with social distancing in place for their staff. This is something that they're sort of starting up at the moment. They're trying to offer a service to deal with a backlog of eHealth orders where it's really urgent for the institution. And if you do want the British Library to discuss what they can do for you when, we would encourage people to contact Sam or Joe at the British Library directly. If anyone doesn't have the contact details and needs them, then I can provide them in the link. But that's what we've been asked to say by the BL. They do hope to restart their service in late June fully, because we know that this is something that is going to be really, really helpful to have available, even if institutions have challenges with doing their own scanning or acquiring content. So we really want to work with the BL to make this happen. So really, that's it for me in terms of an update on CLA licensing at the moment. But please, do watch this space and listen out for what we are able to do in collaboration with the CNAP group and institutions in the future. So yeah, that's it for me. Happy to answer any questions or move on.
That's wonderful. Thanks, James. Thank you very much for that. It was great to get the update regarding the CLA licence and, of course, how it responded to the current pandemic. And once again, thank you to all your work in CNAC as well for making that happen, basically. And thank you also for the update regarding the British Library and the fantastic eHealth service, because it's useful to get those updates as well. I'm just looking at the chat just to see if we've got any comments or questions. Please bear with me. See, I think there was a comment, but I think Jane answered that. And I think we have one more from, sorry, that's somebody coming in there.
Greg,
Yes.
I was wondering if I could come in.
Of
So
course,
I wanted to respond to James's presentation on behalf of the CNAC. So Jane and I are both members of the Universities UK Guild HE Copyright Negotiating and Advisory Committee, so we liaise with CLA on the CLA license. So the license term 2019 to 22, we negotiated those terms that were temporarily changed. So we, just to clarify, we did, as a group, go back to CLA and formally requested that the temporary changes were continued for the whole of the academic year. So all the way from July through to equivalent time in 2021, that would allow institutions to make use of this at a time when, as people are saying on the chat here, we are physically locked out still from our collections. And as James has pointed out, rights holders are not prepared to continue those terms going forward. So we are considering where we go next. As James has pointed out, there's a number of things that they are looking to do from a service perspective. How can they offer additional services? And many of those options are predicated on the idea that there will be rights clearance taking place and potentially additional costs associated with making copies. And CNAC feels that this is extremely disappointing, given that the situation has only arisen because we are not in normal circumstances. So we are considering where we go next with this in terms of what formal representations we make. And at tomorrow's webinar, so Jane and I mentioned the webinars we're running on a weekly basis. We're going to run that as a closed webinar in order to have a full discussion within the sector about what the situation is like for institutions, what we're going to try to do, what would be most helpful in terms of what we go back to CLA with, how we liaise with other institutions or organisations like GIST Collections and the British Library, and what we do within our own institutions and what decisions we make around risk management. So I think we just wanted to acknowledge that James has clearly put a lot of work into creating these temporary measures, and I think there was an expectation that they would continue for some time. So we are disappointed that they're not. Appreciate the tensions involved in this area, but that we are going to continue liaising with the sector and with the community to try to work out where we actually go practically, what next steps, and how do we continue to represent the sector when discussing with CLA and trying to get the agreement of its membership as to putting some reasonable steps in place to allow students to get access to content.
So do we have Jeanette?
I'm here.
Thank you, Jeanette. Okay.
I'm here. I'm not
Thank
late. I just want to thank our fabulous speakers today who've shared their knowledge and expertise that provided us with a wealth of information and real insight into their work. Lots of links to resources such as webinars, mailing lists, games, learning, initiative, and communities. They've brought clarity to the complexities of copyright. And what shines out from our event today is that there is a real, vibrant, supportive community here to support all of us in our copyright knowledge. And I think that's the message we should take away from this. There is help there. We are not isolated and alone. Thanks to SCURL for supporting this event and to the SCURL Copyright Group for organising the day. Special thanks to Greg for hosting and for his very valuable insights. I hope you've enjoyed the event, and I leave you with a quote that I picked up from Jane and Chris's presentation when Jane said, "We're all a bit scared about copyright, but we can be less scared together as a community." Thank you all for your input and your engagement. Take care, stay safe, and enjoy the rest of your day. Thank you very much.